Good morning. Please be seated. We have two cases on our oral argument calendar this morning. We'll begin with Jerry Arnold Westrom versus State of Minnesota. To both counsel, please remember that you'll each have 3 minutes of uninterrupted time to make any opening remarks that you'd care to make to the court. At the end of those 3 minutes, I will stop you if you have not already stopped yourselves. Mr. Nelson, I see that you've reserved 8 minutes for a rebuttal. Is that correct? All righty. If you're ready to proceed, you may do so.
May it please the court, counsel. My name is Eric Nelson. I represent the appellant Jerry Westrom in this matter. On June 13th, 1993, JC was found brutally murdered in the apartment leased by her then boyfriend, AG. Upon investigation, crime scene analysts collected numerous pieces of evidence from JC's apartment, the hallway, and the complex staircase. Of particular relevance to this hearing, these items include a multitude of DNA swabs taken from the apartment, the contents of the apartment, and blood stains found in the complex staircase, as well as footprint lifts found within the apartment. Throughout the course of this investigation, which spanned nearly 3 decades, police developed more than a dozen potential suspects, ranging from JC's boyfriend, her clients, residents of the tower, and other individuals from the neighborhood. JC had worked as a prostitute, and numerous DNA samples were recovered. Some of these samples were identified. Some could not exclude certain individuals. Some samples specifically excluded other individuals, and some samples remained unidentified, and others were never tested. Eventually, the investigation into the death of JC went cold and languished until 2018. Over the decades, as the science of the DNA testing progressed and evidence from the crime scene developed new DNA profiles from certain items that were collected. Investigators gave that profile to a self-titled forensic genetic genealogist who then created a fake user profile and uploaded the single nucleotide polymorphism, or SNP DNA sample that she had obtained from the police detectives to 3 commercial websites. Using this information, the forensic genetic genealogist was able to determine the likely age of the individual, the age range, the eye color, predicted admixture or ethnicity of whom she described as the perpetrator. With that information, she was ultimately able to compare the unknown DNA profile with a first cousin once removed of the defendant. She then constructed a large family tree showing generations of relatives and narrowed her conclusions to Mr. Westrom or his younger brother. Officers began tracking Mr. Westrom through social media and eventually followed him to his child's hockey tournament, where they observed him wipe his mouth with a napkin, discard it into a trash can. Investigators collected that sample. They then extracted, sequenced, and analyzed a DNA profile of Mr. Westrom. The sample was initially used to compare against the unidentified profile that was taken from the crime scene. When investigators arrested Mr. Westrom and then obtained a search warrant.
Counsel, I'm going to stop you. Your time is up. One question I have, what is it you are challenging precisely? Because my understanding when I looked at the district court's order denying your motion to suppress is that you talk about the privacy of the genetic material in the DNA sample, but the police used the sample, it appears, purely for identification purposes. They didn't do sort of the deeper dive into the genetics that the SNP type sample would have allowed. Am I correct about that, or just help me with what exactly you're challenging? Because the district court seemed to believe that you were not challenging the collection of the DNA off the napkin, and so I'm just trying to get a better handle on what it is that you're challenging.
Yes, Your Honor. The specific issue is the search of the genetic material. We're not challenging the collection of the napkin itself. The law is well settled, Greenwood versus United States, that once someone discards their trash, they no longer have that privacy interest. But once the DNA sample was extracted from the napkin, sequenced, and analyzed, it provides a tremendous amount of information.
Okay, let me stop you there. I think we all agree that that's true. It does provide a tremendous amount of information, but my understanding is that's not what the officers did here. They used it solely for identification purposes. They did not look into your client's, all the other information they could have found genetically. Am I correct in that?
You're correct in that insofar as they primarily used it for identification purposes. However, they did have that other information from the genetic genealogist as well.
But does that matter? I think that's what the district court was getting at, and what some of the, well, there's not that much case law out there, but just because they had it,
well, it certainly
is that
matters.
enough if they didn't use it?
It certainly matters, Your Honor, because if you analogize it to the cell phone, for example, we have two very clear cases in the Riley decision and the Carpenter decision that what we're not concerned about, or what the law should be concerned about, is the entirety of the evidence that exists. So imagine a circumstance where if I were at a crime scene and I left my cell phone behind at that crime scene, the law wouldn't allow police officers without a warrant to turn it on merely for identification purposes.
Are you?
How do you, one last question, Justice Teason, if I may, but then how do you distinguish it from Maryland versus King? Because Maryland versus King seemed to say that that was true in Maryland versus King. They could have looked further, but they didn't.
Well, and that's precisely the point of Maryland versus King is Maryland versus King actually says as these DNA, as technology advances, we need to be more mindful of the Fourth Amendment protections. And that's what has essentially happened here is we've advanced even 10 years since Maryland versus King. And with the rate at which the technology continues to advance, its applications are infinite.
Counsel, I just want,
Go ahead.
thank you. I just want to be clear that I'm understanding you, because my understanding is that they took from the napkin a low information STR profile incapable of providing the information that you're talking about. If they wanted to go that next step, they could have send it to the BCA and do a bunch of other analysis, but that they didn't do that. Am I correct? And if I'm correct, how does that play into our analysis?
Well, it was with that analysis that that initial analysis that the genetic genealogist was able to take that information and extract and determine, again, eye color, approximate age, ethnicity. All of that information was taken from that sample.
But that goes to the identity, which is the issue I think that Justice Hudson had raised.
Well, again, the law specifically doesn't say, well, we're only concerned about a limited piece of information. We're concerned, the Fourth Amendment is concerned about the broad applicability, those things that which law enforcement doesn't just readily have the ability to observe.
I need to clarify, because I feel like we're getting a little bit muddled.
Sure.
There's two DNA samples sort of at play here, right? There's a crime scene DNA sample that got the analysis by the genealogist. Is that right?
That is my understanding.
And then there's napkin DNA that got just the STR analysis to match it with the crime scene DNA. Is that correct?
Correct, at least initially. They took that and they took that second sample, compared it against the crime scene sample, but the BCA wouldn't accept that as a confirmatory test. That's what then created the arrest of Mr. Westrom and led to a warrant.
And so which of those, so you have two separate items of DNA. Which of those are you challenging and on what grounds?
Well, specifically I think it applies broadly to
Well, wait, no, but I really want to know for one and the other
specifically
what the challenges are.
the sample that was collected from the napkin.
Okay, so you are not challenging on search and seizure grounds the crime scene sample that got the full SNP analysis.
I believe that in that particular incident, the law enforcement is allowed to collect and seize samples from a crime scene. That's not a question in terms of the search and seizure of it. They can create a DNA profile from it, but then the ultimate question really becomes when we're talking about the Fourth Amendment and grabbing someone else's DNA, extracting it without a warrant at that point.
And are you making that argument as to the crime scene DNA? A Fourth Amendment or Article 1, Section 10 challenge to the crime scene DNA?
To be logically consistent, I believe that the DNA that was collected could be collected, but that the Fourth Amendment would require a warrant to test.
So, but you keep saying DNA collected. The DNA collected from the crime scene could be collected, but to do the SNP, that's a constitutional violation?
To do any genetic testing of that would require a warrant. So just like
From the crime scene we're talking about now.
if I left my cell phone or some other.
So, but are you making that? It's not clear to me that you made that argument in your
Well, I apologize if
brief.
that's-
It seems like your whole thing has been about the DNA extracted from the napkin and not from the crime scene. So, are you making a Fourth Amendment argument about the crime scene or not?
Yes, because, and what I am suggesting is that law enforcement has the authority to collect that evidence, unquestionably, but then to do the genetic testing, the SNP.
That's an additional search.
That constitutes a search necessity.
And that one was an SNP, not an STR. So
Correct.
then King versus Maryland doesn't, or Maryland versus King doesn't apply necessarily. So you are making that argument?
Yes.
Okay. And is that under the First Amendment or Fourth Amendment or under the Minnesota Constitution or both?
Both. I mean, I think that specifically under the Fourth Amendment of the United States Constitution, the privacy interest in that information is found. But the Minnesota Constitution, as this court has made clear in several cases, such as Leonard, Carter, and Asher.
Can you just point, when you come back, can you just point in your briefs and maybe in the district court record where you actually made that argument as to the materials collected from the scene of the crime as opposed to the materials collected from the napkin? You don't have to do it now, but if you're unrebuttal, that would be helpful.
Counsel, kind of as a follow-up to that, that's exactly where I was going as well, because that's not, at least from the way I read the district court's order, she didn't think that you were challenging that. And I didn't think you were challenging that until this very moment. And so that's not how your briefs read, at least to me. And so I'm wondering about, forfeiture and that it's concerning because that's clearly not what the district court thought you were doing.
Well, and I was not the district court counsel.
I'm sorry, okay.
But that being said is I believe that in our brief, we do talk about that the search of any DNA is afforded we have a heightened privacy interest in that DNA, and that a warrant, because of that heightened privacy interest, a warrant should be required to get into all of the genetic information, whether it's SNP testing, STR testing, simply because analogous, again, to the cell phone is it has that possibility to include all of this information about us. And we don't focus specifically on just what the police may be interested in. The law, especially in Riley and Carpenter, talk about the breadth of the information and that's what the Fourth Amendment wants to protect, as well as the Minnesota.
I had one other DNA question that's just kind of a strange one, but there was lots of, I think you referenced it, there was multiple DNA and genetic material found there at the scene. How did they develop multiple DNA profiles from the different DNA left at the scene and submit all of those to the genetic testing, or did they narrow down on one? And if so, why did they narrow down on just one? And maybe I don't understand DNA, but which is probably true, but.
My understanding from the lower record is that there were multiple mixtures of DNA found at the scene. Some of those profiles were identified because they had a record of that person's prior arrest, for example, and they were able to do the loci comparison. Some were not identified.
Did they submit all of those that were not identified, or did they narrow down to one?
Narrowed down to the one.
How did they figure that out? Is that in the record or not?
I don't believe that there's a clear record of how they did that.
Well, was that because that DNA was located on towels and a red T-shirt in the bathroom and on the comforter? I mean, they found this unidentified DNA that was around a lot of the blood on specific items.
Correct. It's my understanding, again, the DNA was found specifically and specifically matched on the towel and the comforter and could not have been excluded from other items. However,
And other DNA was found in the comforter, right? Of
Correct.
another suspect?
yes, correct. I mean, specifically one of the,
I'm sorry, while we're on that other DNA, and the trial counsel was allowed to explore that at trial, correct?
to a limited extent.
Pointing out all the unidentified DNA or DNA from other people without naming the person.
Without naming the person, which I think highlighted specifically some of the errors in terms of the court's alternative perpetrator analysis, because it elevated Mr. Westrom's DNA and it created a more significance. If you have 2, 3, 4, 8 people's DNA on a particular comforter, to say, well, and if we know who 6 of those other people are, or 4 of those other people are, to say it essentially created a timeline of when the DNA was deposited by sort of saying, we're not going to tell the jury whose DNA is here, whose other DNA is here, just that there's other DNA. But it allowed, again, the prosecutor to make this argument that this was Mr. Westrom's wet semen. There was no evidence in the record of when that DNA was deposited on any of those items, which order could have been there for a long time.
And does any of that matter in terms of alternative perpetrator and the threshold test? I mean, can you look outside just the proffer from the defendant to look kind of at other facts that may mean that the proffer is not correct, or are you limited, as a district court judge, limited to just looking at what the defendant brought?
Well, unfortunately, I think the record is incomplete relevant to some of that, mainly because counsel didn't bring forward more information. It was a pretty broad proffer. But ultimately, the analysis that the district court did on alternative perpetrator was flawed really in 2 ways. Number one, the district court judge said that this had to somehow prove that these individuals had committed this crime. That's not the standard. And likewise, the district court focused on the location of this evidence within the apartment. The proper standard is there an inherent tendency to connect?
Can you consider like the fact that the footprints matched Mr. Westrom in assessing alternative perpetrator evidence that has nothing to do with the alternative perpetrators? I mean, it strikes me that that's not the test, but.
Well, it's not the test, and it certainly would have been something that the state could have argued at trial. That being.
Should the district court have even considered that in terms of the threshold? Isn't it just the evidence the defendant proffers?
I don't think that the district court did consider that. The district court only considered what was proffered.
Can we consider that?
That's, I guess, Your Honor, that makes it difficult because there is no real record of all of that other.
Okay, thanks.
Counsel, with respect,
Can I follow up just on that point? Does it matter, I mean, does it matter that this case was tried many years later? So the district court is making determinations not at just the time of the proffer. Does that matter?
In terms of the warrant requirement or in terms?
No, in terms of this alternate perpetrator.
I'm sorry, I guess I don't.
Yeah, I'm going to withdraw that question. I have another one for you on DNA. At the district court, Mr. Westrom referenced Minnesota's Genetic Privacy Act. But I didn't see any mention of any of the violations of criminal law that are now in your brief about DNA. Why shouldn't that be forfeited?
Again, perhaps under the plain error standard, whether or not trial counsel advanced those arguments. The district court ultimately did, however, take into consideration the website's terms of use and found even if there was a violation of the term of use, that didn't constitute a search. But again, that being said, our point is it's not limited only to a civil violation of a private company's terms of use. There were actual violations of the law that were used by the investigators.
Counsel, I noticed there are two charges here. One of them is premeditated murder. Is the question of premeditation, is that before us at all here?
It is not, Your Honor.
Counsel, I wanted to, I have two questions. One deals with the alternative perpetrator issue, but I want to back up to a DNA question first. Do we deal, or are you making any claim that your client did not abandon the DNA evidence that was on the napkin? And I only ask because the district court talks about that as well, saying kind of, and in the alternative, he abandoned it. Are we looking at abandonment at all in your view?
I believe that, first and foremost, when it comes to DNA, the shedding of DNA is not a volitional act. I mean, there's a probability or a possibility, at least, that my DNA could end up in counsel's house this evening simply because we're at this sharing the same podium. So the shedding of DNA is not a volitional act. The discarding of the napkin clearly is a volitional act. So in the context of shedding of DNA, that's why, again, I think that the society is ready to recognize an expectation of privacy in this. We can't control it, first and foremost. And so the discarding of the napkin is one thing. That was clearly and lawfully seized by investigators. But it's hard to say that he abandoned his interest, his privacy interest in his DNA for something he can't control.
What's the difference, though? That seems like a distinction without, what's the difference? What's the practical difference?
Well, the practical difference is, for example, if I leave a fingerprint, there are things that, if I'm interested in murder and I don't want to leave my fingerprints, there are things that I can do to prevent that, right? There are steps I could theoretically take. I cannot prevent the shedding of my hair, my DNA, my skin cells. It's not a volitional act.
Well, what about at the crime scene? I mean, you can. I mean, if you leave your hair or your genetic material at a crime scene, can't the state collect that?
Of course, they can collect it, but the inquiry then becomes, what can they do to test it?
So is the question, there's two separate searches here, even for the abandoned DNA on the napkin. There's the taking of the napkin and then taking of the DNA on the napkin, and then there's a separate search, arguably,
Yes.
to test it.
Right. So, I mean, imagine a situation where I were arrested for some other crime, and police search my pockets and take my cell phone.
And so the question of abandonment really is, are you abandoning, when you drop the napkin, are you abandoning your interest in the information contained in the DNA?
Correct. And I don't think that you are. I think that that society is prepared to recognize a privacy interest because the genetic code contains so much information, much like a cell phone.
Well, I guess we could go round and round about that. It just seems to me when you throw away a napkin and you discard it, whatever privacy interest you had, you're giving that up. I think in today's society, most of us recognize that we're carrying our DNA wherever we go, and when you throw away a napkin,
Well, if I wipe my mouth and there's Heinz ketchup, does Heinz Corporation abandon its interest in its secret recipes? I mean, someone could theoretically extract the recipe there. I mean, this becomes the issue is we may be aware that our DNA is everywhere these days, but that doesn't mean that we are prepared to allow the police to search it in its entirety to glean all of this information about us to use, whether it be for identification purposes, elimination purposes, et cetera.
Let me ask one last question on the alternative perpetrator issue. It seems to me the closest case to me was Mr. Carlton, because he had committed a similar crime around that same time, and his DNA was on the comforter inside the victim's apartment. I'm wondering, though, but the court excluded that. So I'm wondering if you could talk to me about why you think that was error as it related specifically to Mr. Carlton. And in the course of explaining that, I'm just curious, what do you think the district court meant when it said the defense, however, may elicit evidence where his DNA was found, nothing more? And maybe it goes to what you were talking about earlier with Justice Thiessen about, because of the way the district court handled the alternative perpetrator evidence, it really allowed arguably the prosecution to go down a particular path.
That's particularly it. First of all, I agree that is one of the most offensive omissions by the district court in terms of Mr. Carlton. I would argue that Mr. Verhaest is similarly situated in that this was the individual who was there that day, the day of the murder, and made inconsistent statements about it. That being said, Your Honor, and I apologize, I think that the district court, by saying to counsel, you get to identify that there was DNA found on this blanket, right? But you don't get to mention that person by name. That created an unfair advantage, essentially, or disadvantage to Mr. Westrom, because it said, Mr. Westrom's DNA is here, it's clearly identified, it is Mr. Westrom's DNA. But we also found some DNA over here, and, don't pay attention to that. When the DNA was found on the very same item that was most connected to these two individuals, or these individuals. And I apologize, Your Honor, you had a two-part question. I don't think I answered the first part, and I apologize, I don't remember it.
But I think I'm satisfied with what you just told me, so.
Thank you, Judge.
Okay.
I have a question as it relates to the wet semen. I know that you make the argument that there was prosecutorial misconduct, and one of them was the mentioning of wet semen in the closing argument. But as I read that, it seems like that the state wasn't implying that the semen was deposited at the time of the murder, but that in order for there to be this transfer theory, which was posited, that somebody would have had to have Mr. Westrom's wet semen on them or on the object and then deposited it. Am I right about that? Because it seems like that's a big difference.
I think it's both, quite honestly, Your Honor, because in one hand, by allowing the state to argue that it was wet semen and that it was present at that therefore indicated Mr. Westrom must have been there at the time of the murder, I think is factually wrong, because wet semen doesn't have to be, to transfer semen, it doesn't have to be wet. I mean, seminal fluids or the sperm cell factions of DNA can be transferred just like any other DNA, wet or dry.
Counsel, your time has expired. Thank you. We'll see you on rebuttal.
Thank you, Your Honors.
Mr. Petrus.
Good morning. May it please the court, counsel. I am Assistant Hennepin County Attorney Adam Petrus, and I represent the respondent in this matter, the state of Minnesota. Back in 1993, Jeanie Childs was murdered in her own apartment. The crime scene was horrific. There was blood everywhere. Ms. Childs was found on the floor, nearly naked, and had been stabbed approximately 65 times. After she was found, law enforcement immediately began investigating, but they ruled out all of the initial leads, and the case went cold. A quarter century later, new investigators from the Minneapolis Police Department and the FBI and the BCA continued investigating this case, and that evidence that they found led them to appellant Jerry Westrom. Appellant's DNA, both from semen as well as from blood, was found throughout the murder scene. And I can't emphasize enough how extraordinary this evidence is. 4 of the appellant's bare footprints were found inked in blood on the floor near Ms. Childs' body. Following a 14-day trial, a jury convicted appellant in less than 2 hours. Appellant has raised 7 claims, and I don't know exactly which ones this court would like to ask me about, but I will say that 2 of those claims, the denial of the motion to suppress and the partial grant and partial denial of the motion to introduce alternative perpetrator evidence, are very similar to claims that this court heard about 2 months ago in the Michael Carbo appeal. However, the facts in this case surrounding the alternative perpetrator issue in particular are significantly different than in Carbo. Here, appellant sought to introduce evidence from 5 different alleged alternative perpetrators, and Judge Hoyos granted that request with respect to one of them, with respect to Arthur Gray, and then denied the other 4 because the appellant did not satisfy that threshold foundational step of proffering sufficient evidence that has an inherent tendency to connect those 4 individuals to the bloody, brutal murder of Ms. Childs. Judge Hoyos did not abuse his discretion by partially granting and partially denying appellant's request. Appellant also mentioned the genetic genealogist who worked with law enforcement on the DNA profile that was developed from the murder scene. And that genealogist is Barbara Ray Venter, who is a world-renowned scientist who has a doctorate in biology, a law degree, who worked as a patent attorney specializing in biotechnology, and was previously a professor at Stanford. She pioneered the scientific technique that was used to identify what's commonly referred to as the Golden State Killer, and that's the same technique that was used in this case and other cases across the country. That technique did not violate appellant's Fourth Amendment rights or rights under the Minnesota Constitution. And with that, I welcome this court's questions.
Counsel, I know we're going to spend some time talking about DNA, but before we get there, I'd like to talk a little bit about the alternative perpetrator evidence. And I'm troubled by Carlton and, to a lesser extent, Eswine, if I'm pronouncing that correctly. In both cases, with both Eswine and Carlton, there's a DNA connection. We can argue about the science, but there's a DNA connection that places them both at the scene. And particularly with Carlton, we've got some of the traditional things that we looked for in alternative perpetrator evidence, the similar tragedy that was associated with him. I don't get the court's position here that there wasn't sufficient evidence. What more would you need? What's wrong with that analysis?
Let's start with Carlton, and then we'll go to Eswine, I think. Well, with Carlton referring to, I believe you referenced Carlton's other, or say his murder conviction around the same time. That, I don't believe, is considerable under the first foundational threshold step under Atkinson. I think that would constitute reverse Spriegel evidence that could come in, but only after that first foundational step is satisfied. I believe that's what Atkinson says. I believe that a series of this court's decisions talk about that only being
motive yeah, well, okay. So if we disagree with you on
it's
that,
other
that might
evidence.
be, okay.
I believe the language, and Atkinson isn't the only case, but it talks about an inherent tendency to connect to the actual commission of this particular crime, that happened in apartment 2104 in Horn Towers in June of 1993. Yes, that would have been potentially relevant reverse Spriegel evidence, or in a prosecution against Mr. Carlton, Spriegel evidence, but I do not believe that is considered in the threshold foundational step, which is what Judge Hoyos looked at, and when he found that that wasn't met, he just moved on to the next alleged alternative perpetrator. One distinction between Carlton and appellant is there, because I believe Carlton's DNA was found on the comforter, as was Arthur Gray's, as was appellant's. When Carlton was asked, he completely admitted and owned that, yes, he had been in that apartment. Yes, he had been with that victim. And again, the victim in this case has a profession of being a prostitute. There's a clear explanation for why there was so much DNA from a wide variety of people on that bed in that apartment. That was her profession at the time. And just because someone who had used the services of the victim at some point during her life does not mean that they were an alternative perpetrator under the standard of this court's case law. So that's why, even though Mr. Carlton's DNA is on that comforter, he completely admitted that he was there, as compared to appellant, who was, when questioned, who of course denied ever being there, ever having sex with Ms. Childs. There would be no connection to, or no explanation for why he was there, which was fundamentally inconsistent with the forensic evidence. Turning to Mr. Eswine, I will push back, Justice, about saying that was at the scene. This is a 30-story apartment building in South Minneapolis, and I believe Mr. Eswine's DNA was found in a couple floors. I want to say 19, 20, and 21, maybe roughly in that area, but in the stairwell, not in the apartment itself. It's pretty clear that the assault, the brutal assault on Ms. Childs, happened in apartment 2104. It did not happen in the stairwell, given the amount of blood and the 65 stab wounds that I referenced before. And just because Mr. Eswine was in the same apartment building, home to hundreds of residents and many more guests than that, and had deposited some of his DNA in that stairwell, that does not connect to the actual crime scene. The crime scene was not an apartment on the 20th floor, not the stairwell. It was apartment 2104. So I do not believe that DNA evidence with respect to Mr. Eswine would connect him to the scene, which, and again, is not even enough under Atkinson and other of this court's decisions on alternative perpetrator.
Counsel, let me ask you, when the district judge is considering this, can the judge consider, for example, in Mr. Eswine's case, there were witnesses that said how his hand got bloody, and he had a couple people that apparently would testify that he had an altercation with a man in another apartment. Does the district court, that was proffered from, that was the response of the state. But what gets considered at that initial stage?
I think this court decides in alternative perpetrator whether it's more similar, and these are the examples I was thinking as I was anticipating this question, Justice Chudich. Is it more along the lines of like a post-conviction claim where a petitioner is putting out facts that the district court judge has to assume are true, has to take them at face value, no credibility determinations, when exactly what the defense says is what happened for the purposes of whether or not to grant an evidentiary hearing? Or is it something more along the lines of, just to use a different example, say Minnesota Rule of Evidence 807, the residual hearsay exception. And one of the requirements in the rule itself is whether the out-of-court statement is more probative than any other reasonably procurable statement. And I think in that situation, the court can kind of more engage with the facts and find out whether that particular statement, what's reasonably procurable and whether it's not credible. And I guess in going to your question, using those as kind of two different ends of the spectrum, I understand that was the response from the trial prosecutor when Judge Hoyos was hearing oral argument about that case. And I can very much see why it was, because I feel that's somewhat unsettled with this court's case law on alternative perpetrator. And the position of the trial prosecutor was very much that there was a clear explanation.
So what should the rule be, though? I mean, it's a threshold test based on, to me, it's a prima facie case. Is there enough evidence here to create a tendency? Mm-hmm. And in that situation, you wouldn't consider the response of the state. That's why you go to juries. The state can come in and make that argument, right?
I remember you, Justice Houston, I remember making that very same point during the Carbo argument with a different set of an alternative perpetrator facts, clearly. And yeah, I mean, that is, I don't think that is the rule currently. I understand that.
There's just no rule currently, is what you're saying.
I don't think this court is well aware of its last quarter century worth of cases involving alternative perpetrator evidence. I mean, I could cite them off, but it would just not be a good use of anyone's time. I don't believe that particular question is necessarily answered. I thought we do have some case law that says we don't consider the state's case, though, in the threshold test. I mean, I don't want to dodge Justice Chew's question. I think that even, and going back to what I was explaining in response to Justice Anderson, that there is still not enough, just given the DNA with Mr. Eswine in the stairwell, to inherently connect to the commission of the crime, the brutal crime that happened in apartment 2104. But I understood Justice Chew's question to be, well, there was a clear explanation, as to why that DNA was left there because of the fight Mr. Eswine got into and all of the additional law enforcement and actually defense, I believe, investigation regarding that interaction in the stairwell that did not involve Ms. Childs whatsoever. So I'm not sure if I directly answered your question, Justice Thiessen, but.
I think, yeah, I think probably as good as we're going to get under our situation, yes.
Agreed.
Yeah.
Counsel, can we go back to Mr. Carlton, though, and more specifically the concern that Mr. Nelson raised, which is by not allowing the evidence to come in, or not allowing him to argue that Carlton was an alternative perpetrator, even though his DNA was in that apartment, so not an Eswine situation, his DNA was actually in that apartment, it allowed the state to just, it seems to me it did give the state some advantage to just say, well, there's some other DNA there, but you don't get to go into that in any detail. You don't get to question about that. When the state could have done that, if that evidence had come in, the state could have raised all the issues that you raised with respect to Mr. Carlton. Why isn't that the more appropriate route to take?
Because I think you have to look at, and again, I don't necessarily want to, be untoward about any of this, but you have to look who Ms. Childs was and the explanation for why there would have been so much DNA there. And the DNA on that comforter, I agree with one point that Mr. Nelson said, was not limited to appellant, was not limited to Mr. Gray, was not limited to Mr. Carlton. There was more DNA on that particular comforter, again, with the explanation of prostitution was happening.
So your point is on these particular facts, because she was a prostitute, where you would expect to find a lot of DNA.
I don't think you have
that
the
inherent tendency isn't the same. You've got to show something else. Is kind of what I hear you arguing.
I think you say it better than I could with that response. Yes, I think that you have to always look at the particular facts of a specific case. And if Ms. Childs had been somebody else, if it had been at home and not an apartment, if it had been, she had not been in the prostitution line of business, and there would have been no other conceivable explanation as opposed to a, quite frankly, very logical one as to why there was so much different DNA on specifically the comforter, as compared to other like physical objects in the apartment. I sense another question.
Yes, you sense right. To the Fourth Amendment issue on the DNA matters, you heard the exchange with several, that Mr. Nelson had with several of us about what precisely he's challenging. And what I heard today is that he's challenging two things, the crime scene DNA sample as well as the DNA on the napkin. What's the state's position on that? Was that your understanding, or just tell me what the state's position here now is?
I was frankly a little unclear as to what was being challenged on appeal. I was a little bit more clear about what I thought had been challenged down below at the district court.
Which was, let's start there. What do you think was challenged down below?
I think that, I think there may have been like 3 different things potentially challenged in district court if you look at the state's response to the motion to suppress, and then ultimately the order denying the motion to suppress that Judge Holton Dimmick granted. And that's the development of the blood and semen that was left at the murder scene. And to circle back, actually, to a question, I promise I will finish answering this, Chief Justice. But my understanding, Justice Thiessen, something you said before, is that there was a DNA profile that was developed from 2 different things in 2 different rooms of the apartment. One was the blue towel that was in the bathroom, and the other was the comforter. And they were both semen-based. And they determined that this was unknown, but they were the same profile. It is actually a direct match without knowing who it was from those 2 different physical objects in 2 different rooms. And so that is where I believe the one profile itself came from.
That's how they narrowed it down.
Yes.
Okay, thank
And
you.
then later, circling back to something that Justice Chuditz mentioned before, is that once they had the that particular profile, and then later jumping, a few steps ahead, and it was matched to appellant, then it was determined that that profile was also present on several other objects in the apartment, and that is where the blue washcloth, as distinct from the blue towel, the red T-shirt, and then the blood around the sink. But the development, going back to your original question, Chief Justice, the development of the DNA profile from the crime scene, I thought was challenged. Number two is the privacy interest that the appellant was claiming in the shared genetic material or shared DNA that he has with the family members that voluntarily uploaded that information to the commercial websites, and then the development of the profile from the napkin the napkin that was, recovered from the hockey arena. So that is what I understood from the state's response, the district court level, and Judge Holton Dimmick's order to be raised to district court. I did not think those were all raised to this court. Is that?
Counsel, could I shift gears for a moment here and ask you about the footprint evidence?
Yes.
You've talked about the centrality of that in the state's case, and I don't deny that that was an important aspect of the element here, but the denial of the defense expert, well, I guess the second report of Dr. Nierenberg was excluded by the trial court. And as I understand the sequence of events here, there was a FRIMAC hearing on Dr. Nierenberg's first report in July of 21, a one-day hearing. October, that the court denied that evidence, and then there was an effort made to have a second report that talked about the gun method and the overlay method to supplement the earlier one. And the district court, as I understand it, denied that on two grounds. One was timeliness, and then the other was not meeting prong one of the FRIMAC hearing. But if I understand the circumstance of what happened, then the court continued the trial a day or so after that order was issued, and the trial didn't actually happen until August of 22. And so it seems like kind of a tough ruling there to say I could understand if the trial was happening tomorrow and that report comes in, that seems to me well within the trial court's discretion. But when the trial court continues the trial for almost a year, and given the importance of this evidence, that worries me a little bit on an abuse of discretion standard. Help me understand why I might be wrong in being concerned about that.
Of course. As a threshold matter, this is the third issue, as I understand, that was raised in appellant's brief for this court, and appellant does not argue prejudice. He does not explain at all how he was prejudiced by that ruling. It says an abuse of discretion, but he's not under Amos, for instance, which is what I cite in my brief, to show how it would have affected the outcome of the trial in any way. And so on that ground alone, you can deny this claim, Justice Moore. But going back to I feel what was the heart of your question, at that June 10th, 2021 evidentiary hearing, where you had 150 pages of testimony from Dr. Nierenberg, at the end, there was something that was quite unique, and I know from your years of sitting on a district court bench, you'll probably, I feel, agree that it was quite unique in that you had, at the end of his testimony, the cross-examination, him admitting that the conclusions that he put in that original report were essentially undermined and wrong because he had been provided what he thought was, certain information, and he had not been provided that. It was a truly incredible moment from a FRIMAC hearing perspective. Jumping ahead to October, or the end of October, the order had been issued, denying, perhaps unsurprisingly, given that testimony in June, denying the admissibility of his, the real method at that point. And there was a request kind of being, because the defense had realized what had happened at that June hearing, and there was a request for those two other, the gun and the overlay methods. And I agree with you that Judge Holton Dimmick denied it on those grounds. At the time that she denied it, going to the timeliness ground, for instance, she thought that the trial was going to be starting imminently. And then it did get continued, and it got continued even further, because I believe it got continued once the first time, time. And then once it was reassigned from Judge Holton Dimick to Judge Hoyas, it got pushed out even and further back. I don't believe that the district court, either Judge Holton Dimick, right after she continued it, again, after making that original ruling, or Judge Hoyas, when he inherited the case, had an obligation to raise that issue back up again. I mean, I understand
Did counsel
it was,
raise that issue again on the timeliness once the trial was
a second
continued?
Fry Mac hearing is basically what Judge Holton Dimick denied, a second Fry Mac hearing on these different methods that Dr. Nuremberg was positing about the footprint evidence. It was denied, and then defense counsel was full right after the case got continued and after the case got assigned to a different district court judge and continued even further for that reason to raise it again and to put the issue back in front of the district court, and that simply did not happen. So I'm just not aware of any case law from abuse of discretion that would require a district court judge to, when they make a ruling that could be well-grounded, and then part of the basis for that ruling, timeliness, is undermined because the case is continued out for many months, then to return to all previous rulings that they made sua sponte without the defense making that request. And I also do think you can stand behind on abuse of discretion ground Judge Holton Dimick's decision on what was being proffered in October of 2021 regarding both the gun and the overlay method as not satisfying the first prong of Fry Mac.
And that's just based on the lack of information provided in the motion that was made by the defense regarding those methods?
Correct, similar to how there's no information in the brief before this court on prejudice and how those, the analysis under either of those methods would have actually impacted the verdict that the jury reached. I see I have 3 minutes left. I don't necessarily need to take all of the time unless there are questions on this court, but there's just 2 things I'd like to point out quickly in response to Mr. Nelson's argument. We talked about the shedding of DNA being a non-volitional act. Your hair falls out, your skin scales flake off. I understand that can happen quite naturally. That's not what we're talking about in this case. The DNA profile that was developed from the comforter in the bedroom and the DNA profile that was developed from the blue towel in the bathroom, that came from semen. And again, not to get too untoward, but that is the act of ejaculation is what produces semen, and that is an extremely volitional act. This is not something that was absently, left there at the scene. It was a quite volitional act that produced.
Is there a separate search, though, when you take that? I mean, I don't think anybody's claiming you can't take the genetic material left at the scene. The police can't do that. And arguably they can test for STR under King versus Maryland, or Maryland versus King. But here they went and took the additional step of, kind of doing the broader STP. Is that what it is? I can never remember. SNP analysis. Thank you. Yes. Is that a separate, are those 2 separate searches conceptually to gather the information and then to look and try to extract the information from the genetic material or from the DNA sample? Are those 2 separate searches?
In the DNA context, I don't believe there's any case law that holds that there are 2 separate searches. They're 2 separate acts.
No,
I don't
sure,
believe they're
yeah.
2 separate searches. I mean, in Burns, which was not cited in this briefing, but I know members of this court are aware of it. The Chief Justice mentioned it during the oral argument in Carbo. That's an Iowa Supreme Court decision that came out earlier this year. Or Hartman, which is a Washington State Court of Appeals decision that came out on August 22nd of this year. They find consistently with that not being a search, that's that second act. And in terms of distinguishing, in the minute that I have left, I know there's been a fair amount of reliance placed on Carpenter and Riley. And if you read Carpenter, I mean, the opinion is quite clear in how it limits itself. What Carpenter says is that this is a very narrow one, essentially limited just to that CSLI technology that can provide that comprehensive surveillance of a person's physical movements. And then going back to something I heard this court saying a fair amount of before, I mean, the identification information that was, gotten from that second act is different than the concerns that were expressed by Carpenter and by Riley in terms of like the privacies of life and what all of the, I think the language from Carpenter is familial, political, professional, religious, and sexual associations that come from.
Is the question on that reasonable expectation of privacy really do we want to live in a society where the government can take take stuff, maybe if it's left at a crime scene, it might be different, but can take stuff and then go and find out all this information about us? I mean, isn't that really what, I mean, that's kind of what Riley was about. And I mean, that seems to be the actual question we should be asking at least.
Just to clarify. Thank you. Yeah, I agree. I mean, what would be interesting about Riley is twist the facts and say it was a cell phone, or I mean, twist the facts, I say, of this case, it was a cell phone that was thrown away at that hockey arena. And so it was clearly discarded. It wasn't, as was the issue in Riley, a cell phone that was being taken from a person. Because what Riley really focuses on is the search instant to arrest. I mean, it's someone's on their cell phone. You need a separate warrant for that as opposed to what the search instant to arrest normally covers. But what happens if that person, in Riley, had thrown away, consciously disregarded, abandoned their cell phone? Then were police going to, I mean, Riley doesn't hold this, but needing to go get a warrant to search that cell phone that had essentially been abandoned? If the answer to that is no, then Riley has absolutely no application to what we're talking about here.
But still the same question there is, do we want to live in a society where government is going to be able to go and turn on your cell phone, break your password, and access that information, right? I mean, it would be this, I'm just adding, that's the same question we'd have to be asking in both cases, right?
And I think it goes the second prong that comes from Katz about, does society recognize this? I want to get the language right. But yeah, does society recognize that, prepared to recognize as reasonable? And I don't think there is any case law out there currently that says, going back to, you referenced the crime scene, the DNA that was left on the napkin, or that was left in semen form and blood form at the crime scene, to recognize as reasonable, like an expectation of privacy in that. So if you're drilling down just to the facts of this case, then I don't see you can meet that second prong.
Counsel, before you sit down, does it matter, and this is just, I think, a version of what Justice Thiessen is asking, does it matter, or should we care what the police can do with the DNA? I mean, I think that was part of Mr. Nelson's point, is here they used it for, I want to say only in quotes, identification purposes, but they could have used it to find out all kinds of privacy of life kinds of information, his genetic disposition to diabetes or whatever it might be.
I think this court needs to focus its analysis on what the police actually did. And the reason I say that is going back to something that's broader than Riley and Carpenter and some of the other cases we've been discussing about, but that touchstone language of what the Fourth Amendment and the comparable provision in the Minnesota Constitution is all about, which is reasonableness. And the police were looking in a narrow fashion for just the identification in this particular case. And they had exhausted, after a quarter century, any other conceivable way of trying to find the person out. And I would urge this court to hold that what the police did in using Dr. Ray Venter and going about the DNA analysis in the way they did, but limiting it as opposed to anything that would have been protected by HIPAA or any other type of medical information or information about hereditary diseases. No, we're just talking about the identification of the person for solving this really horrific crime that the community, I think, that's what it could recognize actually as objective in terms of conflating two principles, but looking to what the community would recognize as what it wanted to have happen. So I would urge this court to hold that way.
Thank you, counsel.
Thank you for the time.
Mr. Nelson, rebuttal.
Thank you, Your Honors. Just to pick up where we left off right there, Your Honors, I actually think that the Fourth Amendment inquiry is the broad. As we cite in our brief, Langford versus Gelston, we're looking at the entirety of the information that police can not just obtain, not just the information that they deem useful. That was evidenced in the Birchfield case, where the court authorized the taking of someone's blood for purposes of analyzing it for toxicology purposes, but it limits it to that. They recognize that there is a broader privacy interest in that blood. Now the government has the blood. They're limited to only identifying one thing. They can't use it for anything else. So the broad implications.
Counsel, but does it matter that in Birchfield, they knew who the person was? And, they're only interested in knowing if they drove while drunk. And here, that first search, they send it to an expert who has the ability to do this more complicated search that reveals all sorts of things. They send it to the genealogist who comes back with the information that they need to try to solve this crime.
Theoretically, in Birchfield, they know who the person is. They have a sample that they know came out of their arm. What would prevent the police from doing a DNA analysis and comparing it to unsolved crimes?
Well, I think we would find that's unreasonable under the Fourth Amendment. But this seems different to me. When you don't have any idea who this person is, this person has committed a really horrific crime, left behind genetic materials that can identify them, and then the police are simply trying to use this new thing at their disposal to find out the identity.
I don't disagree, Your Honor, that society has an interest in solving murders. But the act of getting a warrant, especially in the modern era, is so simple. It's an email, essentially, through the electronic system. It's not unreasonable to...
You could certainly rule that way for prospective cases, but I don't know that what the police did in this very forefront of this new type of thing is unreasonable.
Well, I mean, again, when we talk about, when we analogize it back to just the line of cell phone cases, right? It was, all of this stuff has been emerging, and it does have a backward look. So I wanted to address a couple.
Can I just ask one more question on the DNA? So if the search of the information from the DNA drawn from the genetic material is a separate search, then why is it not the implication of that the police have to get a search warrant every time, so they find all kinds of stuff at the scene? My understanding now, maybe you do, but my understanding is you don't get a search warrant then to test the DNA?
That's the current process.
So is the implication of your argument that anytime you search for DNA, the police can collect all this information and they have to get a separate search warrant to run a DNA test?
That would be our position, Your Honor, because it's just like a cell phone. If we find a cell phone at a crime scene, whether it be the victim's cell phone, whether it be the defendant's cell phone, we require a warrant.
And you're not distinguishing at all between sort of the older technology, the STR, and the newer technology, the SMP?
I'm not. Briefly, I wanted to address the arguments that counsel makes relevant to the footprints. I think that this presents a couple of issues. First and foremost, as you raise, it goes to this question of whether the district court erred or abused its discretion by refusing the admissibility of the defense expert. At that time, both parties, the state and the defense, agreed that a secondary Fry-Mac hearing was necessary to determine the admissibility under Fry-Mac of the overlay and gun methods that Dr. Nierenberg had conducted. That's the error that the judge made, is by denying, or by specifically ruling that it did not meet the Fry-Mac standard in her second part of her ruling. That violated the Roman nose, kind of the principle that to determine that you have to do a Fry-Mac hearing first.
But counsel, do you get there? Because it seems to me she ruled before she made that was the last thing she said in the order, is that I'm going to deny the Fry-Mac. But before she said that, she talked at length about how, in her view, the submission of the report was untimely and that the trial had already been delayed 2.5 years, and this was way past the omnibus hearing when it should have come in. And so it seemed to me she was making a ruling based upon the trial court's clearly discretionary call to govern essentially discovery under Rule 9.
I think we also have to take it in the context of the time in which this occurred. This was in the middle of a pandemic, right? That all of this, the materials that the expert needed to obtain to do these methods were delayed as a result of shipping, and the world was kind of at a standstill in many regards. And ultimately, the remedy for a timeliness issue is a continuance. And that's ultimately what happened, was a nearly 1-year delay in the trial.
But that was not known at the time that the order was issued denying on the grounds of timeliness, which is within the discretion of the district court. And does it matter that counsel did not raise the issue again once the continuance was made and then the reassignment to Judge Hoyos?
I think you could include that within the arguments about the effectiveness of trial counsel. With respect to the alternative perpetrator.
Is that a no? I mean, what does that mean?
I guess that's a no.
Okay, all right.
But beyond that, the other point is that it's the burden of the person that's offering this evidence to establish or to show that its method's relatively accepted in the scientific community, and that was ultimately Judge Holton Dimmock's ruling that that standard hadn't been met, and that continues to be a concern on appeal. Was there a proffer that was made regarding that issue to the district court?
Again, I do not believe so. But with respect to the government's argument that there is this clear connection between the DNA in terms of the alternative perpetrator, in terms of this clear connection that Mr. Westrom's DNA is in these two locations. The same argument that the state raises in its defense of the exclusion of Mr. Carlton could be made about Mr. Westrom. Who's to say that he wasn't just a customer that had been there at some point, who had ejaculated on that comforter and used the towel to clean himself up? The threshold there is.
I think it's because we treat defendants and alternative perpetrators differently.
But the threshold question is there an inherent tendency to connect?
I mean, I agree with you. I think our case law says we treat people differently, though, in that regard, right?
Yes, may I respond? I'm out of time.
Yes, finish your answer.
Thank you. The threshold matter being the inherent tendency to connect. And agreed, they treat the defendant differently from.
Whether they should or not is a different question.
Yeah. Is there an inherent tendency to connect Mr. Carlton specifically? His DNA is in the same place as my client's, Mr. Westrom's, and within a short period of time, he's convicted of a very similar murder. That is an inherent tendency to connect. That clearly satisfies the reverse Spriegel standard. Thank you, Judge.
Your time has expired. Thank you to both counsel for the help that you've provided the court here today. This matter is deemed submitted, and we will make our decision in due course. Thank you.